Okay. So once I had a bit of silence in the back, thank you. Well, it's a great pleasure to be chairing the panel 3 on the role of the state for this conference on private international law and sustainable development in Asia. As you know, this is the second annual conference of the Chinese Journal of Transnational Law, and the proceedings will be in due course after double-blind peer review be published in the journal. We hope that by next year. I want to thank in particular my co-editor-in-chief, esteemed Professor Sophia Tang, who has mostly by herself organized this conference, as she did as well last year. So thank you very much to Sophia. Thank you as well to our speakers from different countries, in particular to the 3 distinguished speakers who came this week and gave key speeches during the week. I hope you are having a good time in Wuhan. Today we have a sunny day, which is always more enjoyable. And without further ado, let me introduce the third panel on the role of the state. We'll be having 3 speakers. Mu Ke from the Wuhan University of China will be speaking about state-owned enterprises' role in marching towards the Sustainable Development Goals. She will be followed by Zihao from Peking University, which I think is also a former student of Wuhan Law School, who will be speaking about cities' role in transnational access to justice and the sustainable values therein and observation on jurisdictional rules of mainland China, and followed by Jiabao from the University of Amsterdam, who will be speaking about private international law as foreign relations law, reorienting Chinese private international law towards sustainable development. After their presentations, Professor Ralf Michaels and Professor Qisheng from Peking University will be discussing and providing some comments, after which we will open Q&A. You have 15 minutes each, and I'll be monitoring that. So focus on the key points, and the floor is now for Mu Ke, who can please go. Thank you.
Okay, thank you very much, Professor, for your kind introduction. It's my great honor to be here presenting my research on state-owned enterprises' role in marching towards the sustainable development goals. And it's always a pleasure to actually meet the persons whose excellent work I've quoted in my doctoral dissertation and other articles. Very nice to meet you all. Okay, let's get started on today's presentation. Okay, that will do. So the UN 2024 report has illustrated the status quo of the SDG agenda, and it's very unfortunate to find out that it shows stalled or even regressed development over the past few years. We may diverse over the future path of promoting the sustainable development of human society, but we can at least all agree that it's time to take proactive actions now. So everyone shall assume their own responsibilities in this course. My research focuses on the role of corporates. So why corporates? Corporate social responsibility is a perennial topic in academia as well as business practice as an important content of corporate governance and closely associated with the SDGs. It is concerned with the impact of corporate activities on the external stakeholders and the society at large. The traditional paradigm of corporate governance as shown in this chart, is divided by the public, private, and international domestic dichotomies. While this research argued that the boundaries among the four quadrants are actually fading, and the research paradigm should be adapted to the requirements of pluralist global governance and cooperation. The private sectors often contain the stretch of administrative power imposed by the public authority, and the public sectors also leave room for civil autonomy. Similarly, domestic sectors are deeply affected by international environment and affairs, and international sectors increasingly rely upon domestic actors and local governance. So, why I choose state-owned enterprises? There are a variety of enterprises of all kinds of forms, sizes, and equity structures. So why this research pays special attention to SOEs? So there are two main reasons, in my opinion. Firstly, it's an ideal research object and that represents the intersection of all the four sectors mentioned before. And SOEs usually have both public and private ownership, accept both governmental administration and commercial autonomy, pursue both public purposes and private interests. Secondly, SOEs often possess enormous resources and operate in pillar industries, thus have great potential and capacity to make a real change for sustainability on both local and global scales. So this paper also includes an analysis on Chinese SOEs and the regulatory framework of their social responsibility. The big success of China's economy in the period of post-modernization can be largely ascribed to SOEs. Chinese SOEs took up 97 places of the Fortune Global 500 last year. In the first half of 2024, Chinese SOEs made over 14 trillion RMB yuan revenues, contributing more than 226 billion profits and 303 billion taxes. China's 98 centrally administered SOEs have stronger capacity to serve national development goals and strategies, including the SDG agenda. As to the current regulatory framework, China does not have a unified CSR law. Relevant provisions are scattered among various laws and regulations, such as company law, the vocational education law, agricultural, product quality and safety law, so forth and so on. Moreover, these provisions only contain non-binding recommendations and guidelines, like encouraging corporates to publish their CSR reports annually instead of imposing compulsory obligations. So then let's move on to the second part of my presentation, which is the characterization of SOEs from the private international law perspective. So in this regard, a key problem is whether to treat SOEs as commercial entities or state agencies in transnational commercial and investment disputes, or to rephrase the question, whether the doctrine of state immunity shall be extended to SOEs. State immunity sets an absolute bar on the adjudication of states and the execution of state property. There is growing consensus on a restrictive interpretation that the doctrine cannot be invoked when states conduct commercial activities instead of exercising public power. However, it remains highly disputed whether SOEs fall into the commercial exception of this doctrine. The characterization of SOEs is highly relevant to the topic of sustainable development because measures of promoting sustainability are gradually transformed into corporate legal obligations rather than discretionary options. But these measures are traditionally seen as falling within the ambit of sovereign functions. I hereby present 3 typical cases that involve judicial decisions about this question. including one ICJ case, Islamic Republic of Iran versus United States of America, where the U.S. courts block the Iranian state-owned bank's assets. And the second case is an exit case called Beijing Urban Construction Group Company Limited versus Yemen. In this case, the focal controversy was whether the applicant was qualified as a national of another contracting state under the exit convention. And the third case is a Chinese domestic case called Well-Reach Development Limited versus Guangzhou Tunnel Development Company. And in this case, the claimant is an arbitral award creditor. They made a request to revoke the equity transfer from the defendant, a Chinese SOE, and the award debtor to a third party. So these three cases share the commonality in applying the sovereign function test as a benchmark of assessment, meaning that the conduct of person or entity, which is not an organ of the state, but is empowered by state law to exercise elements of governmental authority, shall be considered an act of the state, provided that the person or entity is acting, emphasis added, in that capacity in the particular instance. So, however, it's actually very difficult to characterize the acts and capacities in practice because they may have multiple purposes and implications and can be interpreted either way. So based on the theoretical analysis and case study, I propose 4 key findings in this research. So firstly, judicial practice of characterizing SOEs is far from consistent. Adjudicators often address one or more of these criteria and place different weights on each one of them. At least state ownership and control through direct investment or political power. Second, the nature of the activity or property in dispute or at issue. 3, the principal purposes and activities of the entity. And last one, the specific purpose of the entity's act of property at issue. And my second key finding is that neither of the 4 criteria suffices to characterize SOEs for the purpose of applying state immunity. And I think is a promising alternative would be a but-for test, which examines whether the SOE could have carried out the same act or could have obtained the same property without relying on state power. If the answer is positive, of course, the state immunity should not apply. And thirdly, it is further argued that the SOE's performance of sustainability obligations should not always be seen as an exercise of sovereign function. Thus, it could actually be excluded from the application of state immunity under certain circumstances, like when the but-for test suggests as such. And the last one, I think the spirit of balancing, or say the principle of non-discrimination, should be always prioritized. It means, firstly, to balance the rights and obligations of SOEs. If SOEs are characterized as non-state entities, then they are entitled to all the benefits and protections provided by PIL authorities. Otherwise, they may enjoy the privilege of immunity in judicial proceedings. Secondly, we should balance the private interest of SOE's commercial partners or counterparties and the public interest in sustainable development. In other words, the sustainability requirements imposed on SOEs should not constitute any discrimination against the shareholders, investors, or buyers. If damage is inevitable, remedies and compensations should be made available. So this is pretty much that's my end of presentation. Thank you all for listening, and thanks Wuhan University to provide such a wonderful platform for our communication. Thank you.
Thank you very much for your presentation on matters related to the doctrine of Iuri Imperii and Iuri Gestionis, at least how in public international lawyers would look at this. I like to remind that you can have a look at the article published in the Chinese Journal of Transnational Law just last year on the basis of the conference we organized on the new Chinese law on state immunities, which may also be relevant, I'm sure, for your final, I hope, article to be submitted in your course to the journal. Without nothing else to add on that note, I will now let the new speaker, which is doctoral candidate Fan from Peking University, to take the floor. Thank you.
Thank you, Professor. Distinguished professors, colleagues, friends, ladies and gentlemen, good afternoon. It is my great honor to stand on this very podium of my alma mater, Wuhan University, to share my recent research. My name is Fan Zihao. I'm currently a PhD candidate in Peking University Law School. And my topic today is cities' roles in transnational access to justice and the sustainable value therein, an observation on the jurisdictional rules of mainland China. And the structure of my paper consists 4 parts, but due to the time limitation, I will select 2 key arguments, namely the rationale that how cities' jurisdiction promote their sustainable development, and the following examinations based on mainland China's jurisdictional regimes. And at the beginning, I was trying to connect the relevant keywords, including private and national law, jurisdictions, cities, and sustainable development goals, into pairs to see their correlations. But I won't elaborate on this point. What I'm going to do now is trying to find a clue that can connect SDG 11, the city's sustainable development goals, with the SDG 16, promote access to justice. Consequently, the research question here is that how private and national law is, especially the jurisdictional matters, promote cities' sustainable development, despite there is a local national mismatch. That is to say, the private and national law mainly address national level concerns, but the city's issues are mainly local. And to answer that question, we should firstly explore the function of cities' jurisdictions. Here with a historical overview, we can see that cities' jurisdictions was one of the early focal points in the legal studies, long predating the emergence of sovereign states. Although later cities and city-states are gradually replaced by the sovereign states as the international law actors, but this replacement is not on its entirety. So concerning the political functions, it has been largely absorbed by the sovereign states. However, as for the economic functions, such as facilitate trade, attract investment, it still remains significant. So such a 2-tier observation can still be referred today. If we take the public law perspectives, cities' function to retain their safety and resilience are now mainly protected by the states, the state sovereignties especially, as cities constitutes the part of their national territory. But for the functions to achieve inclusiveness and sustainability, they are largely relies on the economic openness and prosperity. And to achieve such a target, private and national rules emerges to provide transparency and predictability. And with such findings, we can further talk about its rationales. I would say that it constitutes a loop or a circle. To be more specific, at the beginning, private international law rules allocates the international jurisdiction to a proper location, including a city. And then allocations provides transparency and predictability for litigants and for the courts. And then after that, transparency and predictability promotes cities' inclusiveness and sustainability. And finally, sustainability requires more access to justice and with high level of private international law rules, and back to the beginning. In this process, two relevant variables that might cause influence should be noticed. That the first one is the sovereign state's international jurisdiction regime for its international litigations. And the second one is how special jurisdictional rules on the city's level can make impact. So our next step is to examine those two variables with the context of mainland China's jurisdictional regime. And firstly, I want to provide an overview to China's jurisdictional structures of the civil procedure law. Vertical speaking, the level of Chinese courts gradually mirrors our administration structure, and all four levels of the courts, that is to say the Supreme People's Court, and the high courts, and the intermediate courts, and the primary courts are all open for to the foreign-related cases. And that is the vertical structure. But horizontally speaking, it is somehow more complicated. So on the other hand, on the one hand, the civil procedure law distinguishes the foreign-related sections from the domestic sections, and stipulates that if there is no provisions in the foreign-related section, Chinese courts can apply the domestic sections to hear the transnational cases. But on the other hand, we can see that we won't go detailed into the provisions, but we can see that the jurisdictional rules and venue rules tangled in both sections. So that might cause some problem with ascertaining the city's competence to hear a transnational case. And I would call that problem an inverted logic. Usually, like Japan, the first step of court to hear a transnational case is to examine if the foreign state has an international jurisdiction over this case, and then they will decide which court on which location should hear this case. However, when the provisions are missing in the foreign-related sections, Chinese courts might apply venue rules in their domestic sections to determine the national jurisdictions. That is to say, the national level jurisdiction is not confirmed, but it's presumed. Also, some recent revisions of the civil procedure law might cause some uncertainty under such mechanism. For example, the 279 of the civil procedure law, the exclusive jurisdiction provision, stipulates 3 different cases. They are all jurisdictional rules, but each one of them lacks corresponding venue rules. This kind of influence will certainly affect the cities providing a predictable access to justice to hear the transnational case, to choose which court on which city should hear this case. And in the last section, I want to introduce 2 specific jurisdictional arrangements of mainland China. Firstly, the China's International Commercial Court, which has been mentioned by many scholarly works. I want to address that for the 2 CICCs established by the Supreme People's Court, the consideration when selecting Shenzhen and Xi'an, there is no doubt that their strategic location and economic development levels constitutes an important factors or considerations. And in return, CICCs are expected to further promote the relevant cities' outward economies. So this kind of city courts connection is also envisaged when the 12 local ICC's international commercial courts were gradually established around China. Some of them are more like chambers inside the court because they only reallocate the transnational cases within the city's region. But there are also some other courts that can hear cases beyond its boundaries, which is more like the next arrangement we are talking about, the centralized jurisdictions. So the idea of this design is to let the courts expand their jurisdiction to a larger geographical scope based on a SPC regulation in 2002. So in reality, the model is that the intermediate courts in cities with high level of economy standards can replace primary courts to hear the transnational cases, which is not exactly the same with the civil procedure law. So there have been a long-standing disagreements toward this specific arrangement. So for those supporters, centralized jurisdiction promoted judicial efficiency and qualities when China, like in that time, just acceded to the WTO. But for those against such idea, they think it might be contradicts the civil procedure law, like I said, and it might produce inconsistent interpretation of the laws, and then cause a heavy workload to the different courts, especially courts in the cities. So eventually, in 2023, the SPC published a new regulation that stipulates, in principle, the transnational jurisdictions are given back to primary courts. However, we can still see that some local ICCs and specialized courts, such as IP courts in Guangzhou, might constitute exceptions. So to draw a conclusion, our analysis here on the above arrangements especially shows that when cities' jurisdiction under private international law can facilitate cities' sustainable development, but we must admit that cities' roles could change with time and differs among the different locations. So if we take the sustainability requirement into account, we should constantly review whether or not the systematic designs are aligned with the pace of cities' development. And that shall conclude my presentation. I think I have saved 3.5 minutes, and thank you very much, and looking forward to your comments. Thank you.
Much Jiabao, in particular for highlighting the important role, considering demographic trends that cities, megalopolis, of which we have several in China, like Chongqing, with 35 million people, Shanghai, with over 25 million people, Beijing, with over 20 people, or of course, in Japan as well, will play in the future, and how, therefore, the framework, legal framework should consider, especially since demographic trends indicate a greater and greater increase of the importance of cities for the 21st century. And they play definitively a very important role in achieving the Sustainable Development Goals. Now we pass to Jiabao from the University of Amsterdam. Floor is yours.
Oh, thank you, Professor Ignacio, and good afternoon, everyone. I would like to first express my sincere gratitude to Professor Tang and our student volunteer for organizing this conference, which is amazing. And also my gratitude to Professor Ralf, Veronica, and Hans for initiating this very intriguing project on private international law and sustainability. It's my great honor to be involved here today. And so I would like to start my presentation with a quote from Christopher Whitelock. All are ultimately traceable to politics. Whitelock rightly points out that politics matters in introducing external and substantive values into private international law. He also acutely observe that different countries and regions follow different paths in which politics influence private international law. And this leads to my attempt to map the Chinese path, because in China, private international law tends to be detached from and ill-equipped for substantive concerns. And here is my hypothesis that the Chinese foreign relations law, as an important legalization of Chinese politics, projects sustainable development as a political agenda and substantive value on Chinese private international law. In order to validate this hypothesis, my article primarily addressed two questions. First, how the foreign relations law, which seems to fall within the public law area, implicates a private dimension. And second, how the foreign relations law reorients Chinese private international law towards sustainable development. Let's begin with introducing the foreign relations law. It represents a key move in China's political agenda to build a robust system of foreign-related rule of law. This system reflects China's determination to promote foreign relations and policies in a rule of law method, contrasting relying on political discretion. And the Chinese government aims to clearly define at the level of law what China's foreign policy is and how this policy can be implemented. The foreign relations law serves as a basic law in this system, so providing general answer to this what and how question. The answer to the what question makes clear that sustainable development is a fundamental goal in China's foreign policy. Among many objectives and principles, sustainable development is implied in a framework of localized concepts of sustainability. This globalization here means translating sustainable development, which is a global value, into ideas that more align with China's culture and China's specific concern regarding sustainability. This framework is centered around two Chinese ideas and also further encompasses other concepts. While these concepts respectively carry certain values that are encapsulated by the concept of sustainability, sustainable development is recognized as a crucial objective in the system of foreign-related rule of law and also China's foreign policy. The how question has two dimensions. First, it in general inquires the scope of the legal tools to promote China's foreign policy, whether these legal tools will be confined to public law or further include private law. And this relates to the very interesting scholarly reaction to the foreign relations law, where not only public but also private international law scholars actively reacted to this act. But curiously, most of the debate, if not all, focus on the public law aspect of the foreign relations law. Even the private international law scholars seldom examine any potential link between the foreign relations law and private international law. But in fact, private international law is indispensable for the foreign relations law to deliver expected results. To begin with, Karen Knope's perspective on foreign relations law as a broader and finer normative net is helpful here. Following this perspective, it could be understood that the Chinese foreign relations law is an act to weave a normative net called the system of foreign-related rule of law. As Knope observed that only focusing on public international law will render a substantial loss because public international law denies sub-state actors as legal subjects and overlook domestic issues. By contrast, the foreign relations law of China highlights the role of the enterprises, NGOs, and individuals, and also attach importance to both domestic and international rules to implement China's foreign policy. Duncan Kennedy's theory on the decline of public and private distinction also applies. Kennedy observes that fewer scenarios now can be neatly classified as public or private, leading to a spectrum where most situations fall in between. This phenomenon has become even more striking when the globalization permeates and intertwines the public and the private spheres. So governments can no longer rely solely on public or private law to develop their foreign relations. The foreign relations law of China is exactly produced in this complexion and therefore become no longer absolutely public law or private law, but rather share some characteristics of each pole. Furthermore, private international law is functionally necessary. The foreign relations law structures the system of foreign-related rule of law with two phases, struggle and cooperation. These two phases can sometimes conflict, making it critical to coordinate domestic and foreign interests. Private international law is crucial here as it embraces unilateralism and multilateralism, can offer different techniques to balance local and global consideration in a case-by-case manner. So put all this together, private international law should be approached as a form of foreign relations law and be listed as a legal tool within the system of foreign-related rule of law, which takes sustainable development as a crucial value. And since that, for the first time, Chinese private international is linked with sustainable development at the level of law. Another dimension of the how question aligns with Campbell McLaughlin's theory of allocated function. According to McLaughlin, he argues that foreign relations law involves allocating authority in three dimensions. The foreign relations law in China primarily contributes to the second dimension, focusing on the interaction between domestic law and foreign law, where it brings a revisit to two pairs of basic concepts: the domestic and the private, the public and the domestic and foreign, the public and the private. The Article 29 of the Foreign Relations Law calls for a coordinated approach to domestic and foreign related rule of law, moving away from contrasting the domestic and the foreign. This coordinated approach not only requires investing equal efforts and resources into developing domestic and foreign legal rules, but also, which is more importantly, communicating substantive values from the two pools, internationalizing the domestic value and also adapting the foreign and the international values into local contexts. On the other hand, the foreign relations law involves a wide range of foreign relations issues and also governmental and non-governmental legal subjects. Cross-border interaction at all levels are considered essential for the implementation of China's foreign policy. So the legal tools to enable, facilitate, and regulate these interactions, both public law and private law, are highlighted and encapsulated by the concept of foreign-related rule of law. In this way, the foreign relations law in China reconfigures the public and the private in a complementary way to serve shared goals. As a form of foreign relations law, Chinese private international law can improve in three aspects regarding the domestic and the foreign. First, when domestic courts applying foreign laws, the practice on proof of foreign law should be improved. Second, when domestic laws conflict with foreign laws, the homeward trend should be avoided with a more open-minded application of foreign law to better serve sustainable development. Third, when domestic courts conflict with foreign courts, the rules and practice on foreign non-convenience, anti-suit injunction, and also the recognition and enforcement of foreign judgment should be improved. As regards the public and the private, Chinese private international law can respond in two ways. First, Chinese private international law should accommodate the public substantive value explicitly incorporating preferences when determining the applicable law and implicitly granting the weaker party the right to choose the applicable law. Second, Chinese private international law should coordinate regulatory conflict, especially in addressing political goals. This requires defining the notion of private international as an isolated and closed legal subject, but taking private international as a conflicts wisdom and a set of tools to address conflicts, not only private, but also public law. As such, private international law, through reacting to the revisit initiated by the foreign relations law, will be able to unleash its potential in promoting substantive values, especially in the one that we are advocated here today, sustainable development. In conclusion, the foreign relations law potentially reorients Chinese private international law through a two-step way. First, the foreign relations law links Chinese private international law with sustainable development through taking sustainable development as a fundamental goal and Chinese private international law as a necessary tool in the China's foreign policy. Second, the foreign relations law reshapes the two set of basic concepts of private international law, enhancing its governance role and regulatory function, enhancing its contribution, its effective contribution to sustainable development. And thank you for your attention. This is all my presentation, and I look forward to further discussions. Thank you.